Good afternoon, everybody. Welcome to the Harrington Carmichael Annual Employment Law Update. We are just letting lots of people in from the waiting room. There's lots of people joining at this stage, so just please bear with me just for a couple of moments while we wait for people to join before we get into the substance here. I'm sure we're all very used to this of Teams now. We have to let the lobby fill up and let people come through. So we'll just take a moment while those who are joining us are able to get in and hear and be able to understand what we've got going on today. So it's a real delight for us to do these sessions, and so important to us to see so many people that we know so well coming in, friends who we've known for years and people who we would like to know better. So please do come and join us. We'll be delighted to have you and to have you listen to what we have to say today. So this is our annual employment law update. I think is the place to start. It's probably my favourite session of the year. It's the one session of the year that I'm allowed to present with Darren online. Now, those of you who have done this before know that we generally are mean to each other and we generally drop each other in it as we go along. So we'll see what happens today as to how nice or otherwise we are. But as we've got people joining, what I'll do is I'll just tell you a little bit about Harrington Carmichael. So we are a full service law firm. What that means is we're based in and around all areas of law. We give legal advice to UK and international entities, and we're top ranked in Legal 500. That means that we're very good at what we do. But why are we very good at what we do? It's because we're relationship lawyers. We want to get to know you, and we want to know you really well. So if you're our client, we want to know everything about what you're up to, what you're planning, what your strategy is. If you're new to us, we'd just like to get to know you and what your aims are and what you're planning on doing next. So please just, get in touch, get to know us, and we'd like to get to know you too. So you've realised that I've been talking to you now for about a minute and a half, but I haven't really properly introduced myself. So let's do that next. My name's Alistair McArthur. I'm the partner and head of the employment team with Harrington Carmichael. I have the job or the fun job of navigating the ship that is our employment team. And I do that very, very ably assisted by Darren, who looks after me and keeps me in order. Don't you, Darren? So I'd like to introduce Darren, my fellow partner for the employment team, too.
Afternoon.
What are we going to be talking about today? We're going to be going through a review of the key changes from 25 in terms of what took place, where are we up to? We're going to be looking at things coming up, and we're going to be considering how your organisation can get ready for some of these changes. And we're going to be trying practical as we do. Now, unless you've been living under a rock for the last probably 18 months, you'll know that we are in the biggest evolution of employment law that we've had in the last 15 years. And we're literally going through the process of it now. And things are changing, and they are coming fast, and they're coming in unexpected ways as well. So today is going to be very much of an overview session. We're going to canter very quickly through lots and lots of topics. Please don't worry. We'll be sending out these slides as a piece of follow-up. So you will get the slides, you will get the content to have a little bit more detail too. But we've got about 30 slides to get through today, and I've got an hour to do it in. So I want to make sure we give each slide a couple of minutes, and then we'll move on. It means we're not going to get into a lot of detail. But if any of the topics are really of interest to you, drop us a line, get in touch. We'll be happy to have a chat in more depth about the topic itself. Always happy to do that. So, right, without further ado, I'm going to hand over to Darren, and he's going to kick us off in terms of what we have seen so far. Oh, actually, no, it's me, isn't it, still? It's me still. Sorry, I always thought it was you, but it's me. Apologies. So where are we now? I've given some of that flavour already in the context of the Employment Rights Act 25. So the Employment Rights Act 25 came into law just around Christmas time. We'd seen it coming for probably 18 months in the context of the inception since the Labour government election. We've seen lots of things proposed. We've seen lots of things coming in and coming out. Key topics that were dumped, that they got rid of, were things such as the single worker status was entirely removed. They got rid entirely of economically wide fair pay agreements. There's a little bit of some of that in terms of adult social care only. Trade unions, different things have come in. You're no longer going to be automatically opting into trade unions. We've got different trade union rules, which we'll pick up later on. and the idea of the initial period of employment. Now, this was the big debate about how are we going to implement the change to the 2-year rule, which Darren will pick up. There's so much else that we're not going to cover today, which is just on that slide there. But we've been through a lot of change and a lot of updates in terms of what the Employment Rights Act means. And slowly but surely, things are starting to crystallize. So we're going to try and bring a little clarity to that by talking about unfair dismissal first. Over to you, Darren.
Start with the good news, eh? And look, the news isn't that great, to be honest. We'll try and say it with a smile, try and help you get through it. But life is going to get tougher for employers, as I think we all know, and for HR teams. Let's try and get in some of the detail of it. A lot of it you know, but we're going to update you on where we are. So the biggest change, or at least the one that lots of people were talking about from way before the election, was this one. So the removal of the qualifying period, which we've had for a long time now at 2 years. So we've all been used to essentially having a 2-year probationary period within which it was relatively easy to dismiss someone for things like poor performance. We'll remember that the government were elected on this idea of day one rights, meaning that you know, from day one, you wouldn't be able to do that, and it would be difficult. You'd have to have a fair reason to dismiss someone, and there were various discussions from them about how we would do that. But long and short of it is, it's been basically scrapped. It went between the Commons and the Lords, back and forth. There was such an uproar from the Lords and from business that the government decided to give in. And essentially what we've ended up with is a reduction of that 2-year period to 6 months, which is easier for us to understand, but it's clearly going to have a huge impact on us employing people and doing our jobs in HR. We will need to give written reasons for the termination, but we need to be aware that this is coming in from the 1st of January. So essentially that means that anyone that's employed from July this year, who is still employed as at the 1st of January, this will start to take effect from, and they'll have unfair dismissal rights, which means that we won't be able to remove them. So the things that we need to do here, basically, we need to get recruitment right from the start. We need to put much more effort, much more resource, time and effort into making sure we're getting the best people in those roles from the beginning. We're going to need to adjust our probationary periods. We're going to probably bring those down to 3 months. We're going to have to put in lots of checks to ensure that our managers are trained on monitoring during the probationary period, having a review midway, and then actually enforcing it yes or no at the end, instead of what's been happening over the last few years, which is, managers tend to sort of not address probation and it sort of limps over the finish line. If we have a 3-month period, then you can have a short extension, and we need to then be making tough decisions way before that 6 months. No more good news, I'm afraid, on my next slide, because then I've just told you there's going to be a lot more unfair dismissal claims, because a lot more people are going to be eligible to bring a claim. And then the cherry on top is that the compensation limit is being removed. So at the moment, as you know, if you bring an unfair dismissal claim, there is a cap in the amount of money that an employee could get awarded, which is either a year's pay or the statutory limit, which is currently 118,000, whichever is the lower. That is being scrapped also from 1st of Jan, which means that no longer can you tell your CEOs and boards that in an unfair dismissal case, the worst scenario is X amount of money, because now, like we've had with discrimination and whistleblowing claims, there's no upper limit. All the other principles still apply: mitigation, trying to find a job, things like that. But you can no longer have that guarantee. So it's a double whammy, I'm afraid. And just a quick mention on employment tribunals. There's been a huge increase. You'll have seen it on your desks. We've seen it. We've got the highest ever litigation workload we've ever had. Between the last quarter of 2024 and the first quarter of this year, claims went up by over 50%, and there's a huge backlog in the system, and claims are getting listed now up to 2030, which is a nightmare for all of us. Nobody really wins from that. So you're going to have a lot more claims on top of the already lots of claims that are already coming in through the use of things like AI and tools that employees are using to bring complex tribunal claims, no longer just unfair dismissal, but all the other stuff that AI helps them with, which is irritating, but we know that, which of course means for longer hearings. Okay, so then moving on, did we get any better good news? Not really, although this one isn't as bad. So this has now come into effect from earlier this month. So SSP now payable from day one, and the minimum earnings threshold's been removed. So before we had to wait 3 days before people became eligible, and I would believe that was designed to try and discourage sort of, ad hoc, quick one day absences and make sure people were sort of dedicated to being sick before claiming, but that's now gone. So everybody can claim SSP from day one. But just to make sure that people under the threshold don't end up getting more than the statutory amount, if you earn less than the threshold, then you just get 80% of your weekly earnings as an SSP payment. So this is a huge welcome from the unions, very well received with employees, but obviously cost and headache for the employers. Now, does it get any better? No, it doesn't. I'll say it with a smile to try and make it easier, but we're moving on to sexual harassment and whistleblowing. So again, early this month, sexual harassment and the disclosure of it now is included as whistleblowing, as a protected disclosure. So nothing changes with is it a protected disclosure, the qualifying aspects, is it a protected disclosure? The normal thresholds still apply. It's just that one of the things that can be a protected disclosure is now sexual harassment. So as we've seen rightly, I think, an increase in the laws around this with the Worker Protection Act from 18 months or so ago, this is more of the same to protect those that have been the victim of sexual harassment. And one thing that we should always mention with protected disclosures is that someone just has to have a reasonable belief in what they are saying to you, what they are disclosing. So it doesn't have to be true. And I think it's always useful just to make that point, because that sometimes can be overlooked. So now sexual harassment can be a protected disclosure. Cantering on, we've got, again, now this is coming. We talked about this a lot more in our last year's session, but we've now got to the point where it's come in. So we have now doubled the protective awards from 90 to 180 days pay for each employee if we are obligated to collectively consult, but we fail to do so. So anywhere where we're looking at 20 plus in a consultation period, nothing has changed in terms of the length of that period. So it's still 30 days and 45 days depending, but it's designed to be extra punitive now to employers. So we need to be extra super careful to ensure that we are working out when we have our collective obligations, and ensuring that we then go through that process properly and fairly and in compliance with the law. The bottom point there was going to be discussion about interim relief being available. That is to say that while the issue was sort of pending, an employer might be forced to continue paying the employers if they were still employed, but that's been dumped, which is perhaps the first bit of good news I've given you. I'll see if I can find anything else for you, but it's not on the next slide, which is about the Fair Work Agency. Again, talked about this a lot more last time, but it's now here. So this has brought together a number of other agencies that we had before to enforce things in the labour regulations, so sick pay, minimum wage, other things. Now the Fair Work Agency, under the control of the Secretary of State, has the ability to take enforcement action, to apply costs, to bring employment tribunal claims on behalf of individuals. And I think we need to wait and see how prevalent this agency will be. This is my only thoughts. It's personal, but we have had bodies set up before where we think, gosh, you're going to do such big things, and gosh, we ought to be very nervous about this. And obviously, we want to make sure that we don't fall below the legal standards and the things that we have to do. But I am interested to see how busy the Fair Work Agency will be, and how enforcy they will be. I made that word up, but you know what I mean. So we'll wait to see as that goes through. Now, on the next slide, we go back to ET claims, because we've all been used for almost all claims having a 3-month limitation period. in which an employee has to start the claims process. And of course, now and for a while, that's meant going to ACAS to start the early conciliation process, and then the clock is stopped and other things. The government have decided that that was not long enough, 3 months. And so probably from October this year, it's not been set in stone, but we're told it's probably October, it's going to be increased from 3 to 6 months. So it's going to be doubled. So you remember I said a moment ago about the huge backlog in employment tribunal claims and the fact that the system it's not creaking, it's just broken. Well, not only are you going to be able to bring extra claims for the reasons I've already said, but you're now going to see extra claims because there is a longer time frame to bring it. We know things like discrimination claims, whistleblowing claims, it's not been too difficult to still bring a claim out of time, but certainly unfair dismissal claims, it was pretty hard to get an extension. So that did cut off a number of claims, but not anymore, not when it comes in. 3 months to 6 months will be the new limitation period to bring those claims. Initially, it wasn't going to include breach of contract claims, which is a bit odd, and a number of other claims. And the government sort of just went, oops, our mistake. And yesterday, hot off the press, they announced new regulations to bring in the claims that they'd forgotten to include in this other legislation. They've now brought regulations to include it. So whoopsie daisy, but they fixed it. Isn't that good news? We also know that already in place, the early conciliation period for ACAS has been extended from 6 to 12 weeks. Not that you would notice, because you know how overstretched they are as well. Most of you, we don't even get contacted anymore when there's an early conciliation. You just get a certificate, which means you get it at week 12 instead of week 6 from their computer system. And obviously, they're trying to fix it. They're trying to bring in new conciliators. They're trying to bring in new systems and processes. And often you'll now get an email if you are contacted at all that simply says something like, look, do you want to talk about money? If you do, we'll assign a conciliator and talk to you. And if you don't, then we'll just issue the certificate. So I'm not sure that it will notice. If it eases the system a little, that will soon go as the numbers of claims increases. Then what else do we have? So we have enhanced obligations to prevent sexual harassment. So I mentioned that about 18 months ago, October 24, we had a new law, the Worker Protection Act, which essentially said that employers will be obligated to take reasonable steps to prevent sexual harassment. Nobody really objected to this. Obviously, any kind of burden or extra legal hurdles for employers to jump through and over can be unwelcome, but everybody agrees with the premise behind this law, which is to make sure that we do everything we can to reduce situations where our employees can be the victim of sexual harassment. Alistair and I and the rest of the team, we just did so many training courses on this, and it was really good actually to get in front of people. Webinars are great, and it's great to see you all, but it's so good to get in front of a room full of people, to engage with them, to talk to them, to hear stories and share ideas and talk about stuff like this, which we did. And at that point, we were talking about reasonable steps, and practically everyone was saying how difficult that was. Well, it's getting even harder because it's going to move to all reasonable steps, which means if there is a reasonable step that you could have taken that you didn't, then you will likely fall down under this legislation, which means that if a claim's upheld against you for sexual harassment, then there could be up to a 25% uplift in the compensation awarded to the employee, which can be significant. The tribunals will take into account, your size, your resources, your ability, but effectively, this is something that should be on all of our radars. Anybody that didn't roll out training in or around October 24, didn't reissue a new policy, not just amending an existing equal opportunities policy, who didn't do a risk assessment, who didn't take these obvious steps, you have to be doing it now if you're not already. You need to ask us if we can help. We love to get in and see what we can do, but especially now it's moving to all reasonable steps. We definitely need to ensure that we are doing all that we can. So at least we've got an argument that we've taken all reasonable steps. And of course, that 25% is a maximum. So it might be that if we can show we took as many steps as we can, hopefully that would be less than 25% if an uplift was given against us. So sticking with harassment, but broadening it out, the other thing we've got now is, well, it's a bit of history repeating itself. Anyone that was in HR in 2010 might have remembered that when the Equality Act first came out, there was provision for liability for employers from third-party harassment. So if a third party walked into your workplace, and of course they're everywhere, every office has contractors and cleaners, and a lot of us will have clients and customers and suppliers. They're everywhere. Of course they are. But if anybody came in and harassed your staff, first time, you were okay legally. Second time, you were okay legally. Third time, it was three strikes and you were out. Third time, you would have become liable for that third-party harassment under the original legislation. But it was scrapped in 2013. So for the last 13 years, we haven't had this third-party harassment, but it's back, and it's back with a vengeance. It's actually tougher than it was in 2010, because like with sexual harassment, and this applies to all protected characteristics, by the way, you need to be able to show that you've taken all reasonable steps to prevent harassment. And there are things that you can do. You can get clauses in your commercial agreements with third parties. You can put some signs up. You can train people. You can have clear reporting and complaints procedures and make sure that people are trained to look after people that bring those complaints. And there's lots of things that you can do, but this will be difficult. And I really do encourage you to reach out and ask us a bit more about how we can help you with this, because this is going to be something that's going to be big, and it depends on your sector. You can imagine if you're in a hospitality business, this is just huge, and it's going to be almost impossible. The government have said that they will help us, thanks, by publishing some things that they think will amount to reasonable steps, and things that won't be. And we wait to see if that helps us. But really, I think this is going to be something that does come to bite us. So I think at this point, with no idea as to whether I overshot or undershot my time, I'm handing back to Alistair.
But anyone who's ever presented with Darren before, you'll know it's quite surprising that actually he was bang on time for once. So that means that I've actually got the time which I should have for talking to you about the next few topics. And I'm going to start by talking to you about the topic of fire and rehire. Now, this is the idea where an employer terminates and re-engages employees on their contracts. This has got bad press for many years now. It's not been liked at all. The idea that an employer will come along and they'll decide they don't like a particular term, or they think they're paying employees too much, so they'll terminate their contracts and re-engage them onto new contracts. And a couple of years ago, there was the ACAS code. And the ACAS code came in, which set out parameters for employers to follow if they are going to terminate and re-engage employees. That code is still there. That code is staying, and we'll talk about this a little bit more on the same slide, because that code carries a 25% uplift. What's coming in, and it's due in later this year, is the idea that of an automatic unfair dismissal claim. So if an employer dismisses an employee and re-engages them in relation to one of the restricted variations, those things on slide, then there would be an automatically unfair dismissal, which would give the employee concerned the greater ability to go away and pursue a claim. They would have the ability to get basic awards, potentially loss of earnings if it relates to pay reductions. Now, this is not to say that you can't do it at all, but you're going to be very, very limited in the circumstances when you can. And the idea would be that you can only do it when you're facing severe financial difficulty. What severe financial difficulty means, how that's going to be looked at, is going to have to all be set out and considered and set out in policy. Now, many of you will sit there and say, well, I've never terminated anybody's employment or re-engaged them because I've always agreed it. Any change I've had to make, I've always agreed it. And that's still the case. You can still agree changes, and you can still do that through collective bargaining. But the reality will be is that employees will be in a better position to say no to you. As the law currently stands, you can still agree the change, but if they didn't agree the change, the employee's got very little comeback, potentially. This is giving them a greater set of armory to turn around to you and to say no. Government is currently consulting on other areas where there may be restricted variations. The point is that if something is not a restricted variation, let me just click back to the previous slide so you can see those things: pensions, performance, pay reductions and such like. If it's not one of those things, then you're still in the situation that you were before about effectively having to comply with the ACAS code and the potential uplift in compensation that would apply. So what does this mean in practice? This means in practice, get your contracts right now. We're going to come back to that toward the end about the things that you need to think about and the things you need to do. But be aware that whatever you are employing your employees on, the terms you're employing them on now may well be the terms you're stuck with. So let's get it right before we get too far. We're going to go back and we're going to talk about collective consultation for a minute, because there is further changes to collective consultation. So Darren spoke to you about the increase in the protective award. The protective award has already increased from 90 to 180 days. I think my maths are right, 90 to 180. What we're now seeing is consultation taking place in relation to changes to the threshold where collective consultation is required. Currently, the law provides where an employer is dismissing or proposing to dismiss 20 or more people at one establishment within a 90-day period, you have to collectively consult. That has been settled law for quite a long period of time. Often you find discussions around whether there's 20 or more redundancies taking place within the 90-day period. Have we got to that critical number? And often we see discussions around whether they're all at the same place of work, the single establishment. Government doesn't like this single establishment principle, but equally doesn't want to get rid of it where you are a small employer. What they're looking at doing is looking at imposing higher thresholds where there are company-wide redundancies that take place. And the numbers currently being banded around are somewhere between 250 and 1,000 redundancies taking place. That there would be the higher threshold that would apply where collective consultation can take place. I've seen it done on percentages of the workforce or numbers within a specific geographical space, but this is all being consulted upon. And really the message today is watch this space, because what you're going to have is where you're doing pockets of redundancies across larger organizations within periods of time, you're going to find yourself triggering the obligation to collectively consult. Many of you may say to me, well, we've already got people forums, we've already got consultation forums. We would tell them anyway. You might do, but you're going to have to comply with the statutory framework every single time that takes place. So it is important to make sure you watch it, you check it, and keep on top of it. All the existing consultation rules will remain unchanged. So the existing things which we're looking at, such as the 30 or 45-day periods, remain unchanged, along with the requirement to consult with appropriate representatives. They're just looking at that golden number of 20, and can they put a higher burden where there's more taking in place. I think this will come. Personally, I think the number will be low. I think it will be something in the bracket of about 200 to 250 people being made redundant. And frankly, I think that's in some ways right, because where you're making that number of redundancies, actually, a little bit of good news is probably it's easier to collectively consult with that number of people than it would be to hold 200 individual consultation processes. But let's see. Let's talk about flexible working next. Now, many of you have flexible working policies, many of you have agile working policies, and many of you work in flexible environments. Fantastic. I commend you for it. That is absolutely the way we used to be as modern employers. And actually, lots of us do that in relation to how do we attract talent and how do we keep talent when we've got it. What I'm talking about now, though, is the statutory rules around where you're going to refuse a flexible working request. We're seeing less and less and less refusals, I have to say, and that's because as we are seeing workplaces becoming more flexible, employees learn what they can have and what they can't have and generally fit within the frameworks which exist, so that you find that employers generally don't have to refuse them. But from time to time, we do get into a situation where we do have to refuse a request because the employees ask for something that we can't accommodate. What's not changing is the 8 fair reasons for refusing a request. Now, I'm sure you're like me. When you get to a situation where you're having to refuse a flexible working request, you probably type into ACAS or you type into Google, you ask them what the 8 fair reasons are, and you'll all remember they're things such as meeting customer demand, reallocation of work, and effectively working practices. What you don't currently have to do, which may surprise some of you, is you don't actually have to justify your reason. You just have to give it. So if your reason is that you can't allocate the work between colleagues, that's all you have to say. You don't have to give any justification for it at all. What's coming and due later this year is the idea that you'll have to give a justification in relation to the reason. So you'll actually have to explain the reason and show it's reasonable in terms of your decision making. That's placing employers under a higher bar to produce evidence effectively as to why a flexible working request was declined. So, for example, if we're talking about meeting customer demand, we may have to show what the customer demand is, and we may have to show why the change in the pattern would mean that we can't meet the customer demand. Is it because demand is high at particular points of the day, or is it because the demand is so high that we don't have enough employees to meet that demand? We've got to have to produce data to back up our reasons as to why. And that is going to be a big mindset change when we're coming to refusals. It's going to have to mean a lot more analysis, and it's going to have to mean that the reasons are well set out. It's also going to mean employees are going to have a better ability to understand why you may be rejecting, excuse me for clicking onwards, but they may also challenge that data, challenge that information, saying, no, what you're saying is not right. So key thing I'm going to say to you here is, where you have a situation like this, take advice, make sure it's clear, make sure it's well set out. The consultation is also running currently, due to end literally today, in relation to a change in process, so a light touch process in relation to refusals and how the request is not, where requests are not agreed. And this is all still to come. We look for the framework of that. For the time being, though, we have the statutory scheme laid out in the Act, and you should be following that. Lots of you have it in policy, though, and if you have it in policy, follow policy. Right, so let's canter forward. We're going to talk about equality action plans and reports, and then we're going to talk about menopause action plans as well. An action plan, just for those of you who need it explained, is the idea that an employer puts a plan in place of action they're going to take to deal with an issue. So what we're talking about here is we're talking about employers putting in place plans of how to deal with equality and menopause, which I'll talk on the next slide. In terms of the mandatory equality action plans, this is being built off the back of gender pay gap reporting. Now, if you're an employer of 250 or more employees, you will know that every year you have to report mandatorily on your gender pay gap. And that means going through the seniority of your organization and lining up the pay grades and demonstrating whether you have a gender pay gap or not. This has been in for several years. The reality is that with lots of employers, when they publish their gender pay gap, it looks really bad. Of course, it looks really bad, because the fact is that lots of different, within the workplace, gender has always been a thing where there's been disparities in pay. Unfortunately, we work hard to equalize those, but it's still a historic issue. We're still working through it. And the statistics, by statistically analyzing it, it shines a light on that disparity. The idea of the equality action plan is that the employer must take what they've got and actually demonstrate that they are building a plan of how to equalize that and to bring equality to the workplace. I only see this as a good thing, frankly. This is an area where employers are held to account in terms of what they have done and what they should be doing, and actually are now being required to sit down and think about, how do we bring equality together? The government has published guidance on it, or they're publishing guidance on it. It is coming. Keep an eye on it. Currently, these are not mandatory. Employers are being encouraged to publish on a voluntary basis, but it is coming as mandatory from 2027. And I see that as good. And we should be seeing that anyway. And lots of employers do these things anyway, because where they publish their gender pay gap reports, often those are provided with statements about things they're doing to work on these issues. In terms of menopause action plans, very similar news. Employers of more than 250 employees also have to have a menopause action plan, currently voluntary from April 26, due to be compulsory from 2027, and government guidance has been published on creating an action plan. And this is, in effect, looking at menopause as an issue in the workplace and how to accommodate and support women going through the menopause effectively, in terms of the steps that we as employers will take to make the workplace accessible and understanding in these environments. And often this looks like training, it looks like support, it looks like help, but it's about being practical, pragmatic, and realistic, effectively building that plan and publishing it. If you have got more than 250 employees, I would encourage you to be doing this right now, be looking at it, building it, because your employees will be looking for it. And if you don't have it, it's going to look really bad, I would say. You're going to compulsorily have to have it from 2027. So it's better to get involved now. And I would encourage, as the action plan is created, that is consulted on with the employee group as to what steps they see will help in this way, so we actually do what our employees want us to do. Again, I think a good piece of news there for many employers. Next on the list is the increased protection for maternity returners. So let's just pause for a minute, because I think often in a maternity leave situation, clients don't properly understand the increased maternity rights that exist. Currently, the law provides that where a woman is made redundant or within 18 months of the expected childbirth, she has the right to suitable alternative employment where that is available. So what I mean by that is, if we put a group of employees at risk of redundancy and we have a woman who's on maternity leave and we have a suitable alternative role available, she takes preference over her colleagues for that. Her male and female colleagues, she would take preference, and she should be placed into that role. It's not any old alternative, it's a suitable alternative, which is a comparative role. It's not that she can't go through the redundancy process. She should be going through the redundancy process. It's about that suitable alternative that's available. That's the law as it currently stands. Now, obviously, women on maternity leave are also potentially going to have sex discrimination cases if a discriminatory decision is made over the termination of their employment, but that's a separate topic. What we're looking at here is we're looking at the dismissal rights. Now, the government is going into a process of looking at whether they could increase the level of protection that exists for employees who are on maternity leave or just following a return to work. Now, let me just pause and think about that. How are they going to do that? Because we've already got only limited reasons why an employer can dismiss an employee: conduct, capability, illegality, redundancy, some other substantial reason. Now, in the very unlikely event that we have a woman who has committed misconduct or gross misconduct, perhaps, I'm not sure that the maternity leave should give her additional protection here, because if she's committed gross misconduct, that's something so serious as to bring the working relationship fundamentally to an end. It's a fundamental breach of the relationship. It undermines trust and confidence. I struggle to see how the government would maintain employment in such a situation. Capability and performance. Well, the woman's on maternity leave. How are you going to performance manage somebody on maternity leave? The reality is that you can't. So you can't really use capability and performance anyway. Illegality is my next reason. If a woman loses if it becomes illegal to employ somebody, I don't see that that's changed as a consequence of maternity leave. Redundancy, we've already got the rights that exist, but the same applies. So, for example, if we've got large-scale redundancies, I don't see necessarily that the additional protection should apply there, because let's say we're closing a workplace. You can't keep a workplace open for a woman on maternity leave. Maybe there's some rules around selection, maybe there's some pieces in there that can be applied, but it's going to be quite hard to legislate for those and to put those into specifics. And the last then is the some other substantial reason, but that is so normally closely tied to redundancy. I'm struggling with this personally, and it's one which I'm going to wait to see how they actually get increased protection in place, which is why we said the precise extent and content of the regulations is not yet clear. This is coming. It's something that the government are very keen upon, but I think the practicality of such is going to be difficult for them to actually put into place. Next, trade unions. Now, there's lots of things going on with trade unions at the moment, and they're all scattered on that slide there. There's things which are coming. There's a lot of things in the press at the moment about trade unions, and I've summarized them all there. I'm not going to spend a lot of time on them because I'm actually going to go to the next slide in the context of the three things that I want to talk to you specifically about, because this is a whole world which you could spend several hours talking upon, and unfortunately we don't have several hours to talk upon. The ideas, though, are that effectively trade unions are going to be much more powerful in our workplaces and have much more opportunity in our workplaces to engage with our employees. I've had the privilege of working with trade unions before. There are many, many good trade unions out there. There are many good ones which will actually help you and support you as employers in terms of how do you manage your workforce. some incredible stories where when the trade union was presented with the allegations against the employee, they've actually told the employee they're banged to rights and the employer should dismiss them and join the employer's side. I'm sure some of us have stories like that too. But I also know there's a lot of fear and anxiety amongst employers about the potential rise of trade unions in their workplaces and what this might mean for them. Three key areas I want to talk about. There's going to be easier recognition rules coming, and these trade union recognition is the idea that a trade union is recognised to collectively bargain on behalf of employees on relation to their pay and benefits. The rules at the moment are quite difficult and quite hard for the trade union to meet the threshold, and the balloting requirements are quite difficult to meet the threshold. And the idea is there's going to be new, lighter, simplified processes. Whether the employees want to be recognised and be recognised by a trade union is still the key thing. It's still the thing which lots of workplaces, they just won't want this. They won't want to have a trade union in their workplace because they'll want to negotiate their terms and conditions themselves. Particularly professional environments, that's what I'd expect. But it's certainly in some other environments, this could be positive for employees where they get representation where they've not had it previously. Now, the big scary one is the second one there on the slide, trade union access. And if you've been watching the press in the last few weeks, this is the one which has caught us all off guard because it's come very, very left field and very, very unexpectedly. And this is the idea which is coming probably later this year in relation to a trade union being allowed to request access to your workplace. The idea would be the trade union would write to you. They would say, we want to request access to your workplace and we want to get an agreement for access with you. And here's our standard terms, or here's the things that we want to agree in terms of access. Now, I know if lots of us received that correspondence, we'd probably throw our hands up and say, oh my goodness me, I don't want that. I don't want to have to take the time up. I don't have the energy for it. I can't get them involved. And the reality is that if you don't do that, potentially there's significant penalties that could follow this. And currently this is in consultation. The idea will be that if the trade union does not allow access, an agreement cannot be reached in relation to access, that the trade union will be allowed to apply to the CAC, which is the arbitration committee in relation to the application of trade unions. They'll be able to make an application that the employer should go and explain why an agreement can't be reached. And then if the employer still refuses and continues to refuse on several occasions, there's fines that are going to be levied by tens of thousands of pounds. Significant fines are potentially talked about in relation to this. So this is something which you as employers are not going to be able to simply ignore. And that's the reason why trade unions are going to be able to get greater access to our workplaces. Now, what does that mean for you practically? Personally, I think it's about good employee engagement. If you've got good employee engagement that they wouldn't want to have at a trade union in the workplace, that's going to be your best protection. Trade unions also are not overly geared for this. They don't have the manpower. They're as understaffed as the ACAS, as Darren was talking about. They're not going to have the ability to come along to every employer in the UK and do this. Some may try, but the reality is that they're not going to be able to because they just don't have the capabilities. But we have to be careful. We have to keep watch on this. And if you receive a letter from a trade union requesting access, please don't ignore it. Please pick up the phone. We'll be happy to talk about it and how we manage it and make it work. And lastly on this slide is then effectively a changes to industrial actions. That's strikes or where there's going to be limited working or such like. The government has reversed lots of steps that the previous government put in place in terms of limiting the rights here. And they're also softening the ballot requirements and the amount of turnout that's needed and the penalties that were involved in it. Now, if you're a business which is at risk of industrial action or an organisation at risk of industrial action, I'm sure you'll be well aware of this. I don't want to go too far. We're very happy to talk to you about what the new rules look like, but they're on the way and coming over the next 2 years. Right, so what else is coming up? We spent a lot of time talking about the Employment Rights Act, but I just want to pick up on one other thing the government are currently consulting upon before we go on to what are the things you need to be thinking about. So what we've got a current consultation which is taking place in relation to non-compete clauses. And this is in relation to the world of post-termination restrictions. And what we're seeing is the government have a dislike of non-compete clauses. So this is the idea that you leave your employer and you've signed a contract which says you cannot join a competitor. the government wants to outlaw those, or they want to limit them in relation to their size and length, and they're going through consultation. This is not the first time that we've been here. In my 20 years of practice, I've seen this consultation 4, maybe 5 times, and it never gets anywhere. But this time it seems to have an added impetus. There's a commercial impetus to it to try and bring greater competitiveness to our economy. Having said that, though, personally, these are things which are very specific to employers. Whenever we're dealing with post-termination restrictions, we're always talking to you about what is it that you're trying to protect? What is the legitimate business interest that you're concerned about? And how do we best protect that? And if those are valid restrictions which can be enforced through the courts, personally, I think that's right. If the employee is going off and doing something disreputable that they previously agreed that they should be bound by, then I don't see why they should be released from that. Certainly, non-compete clauses can be draconian. What I mean by that is they can be overly imposing. They can stop people from earning money. But you should have that discussion at the outset of employment, or at the outset when the contract is being signed up to. It's much easier to do it at that point than to do it later. And often protection can be gained through things such as non-solicitation clauses. I won't solicit the customers, or I won't deal with the customers, or I will maintain greater levels of confidentiality. And often those commercially negotiated terms are better protection for employers than potentially the non-compete clause, which prevents somebody from performing their trade. What we're going to also see, we've already talked about the Employment Rights Act. It would be wrong to not say that there's an awful lot more consultation to come. There's some topics there which we've only just skirted over, and there's some things there which we're going to have a lot more detail to come. I'm going to share some ways that you can access some information on other things in a moment, but just be aware you're going to have to stay on top of all of this, and it's frighteningly hard. And we spend our time looking at this, analysing it, and reporting on it all the time because it's something that we just routinely have to do. But be aware there's so many changes coming that you've got to keep your eyes on them at all times, and they keep changing. Everything is always in flux. So what should you be doing now? This is the call to action. What are the things that you should be looking at? And we're going to be continually updating our information and putting out materials all the time in the coming months. Now, if you're interested in receiving those, drop Darren or I a message, stick something in the chat box, or sign up to our mailing list. We'll be always publicising the materials, the things that you need to know and what you need to be thinking about. Our first one on the list is prepare for the Fair Work Agency. Now, Darren's talked about this, and we wait to see how much teeth this organisation has. But we would encourage you right now to be auditing your organisation and looking at it in the context of where are you at risk from the Fair Work Agency. Because if you tackle the areas of wages, holiday pay, commission, and the areas where the work agency potentially can attack you, you're at much real reduced risk. And I know for many of us, things such as holiday pay and commission, or holiday pay and bonuses, have long been a topic which we've struggled to get our heads around. Now is the time to do that. Now is the time to get ready in relation to these issues. Our next thing is to effectively train your managers. I cannot say it highly enough, in this new world, your line managers are going to have to be well trained in relation to how to manage people. Darren's talked to you about the changes in terms of the 2-year rule. In some ways, as an employment lawyer, I rub my hands together a little bit with glee at employers who may well get it wrong and create work for us as employment lawyers where they've dismissed people who have more than 6 months service. That's coming. You can't avoid it. Managers don't know this. They don't know that this is changing. They will still behave in the same way. Oh, we've got 2 years. Why are we worrying about it? Let's just get rid of them. Make sure you have your processes in place. Make sure you've trained your people. Make sure you're training your people to be ready to deal with equality issues, being ready to deal with flexible working issues, being ready more generally. We run an extensive program of manager training. It's something which we're out doing almost weekly. It'd be great to come and meet with you. It'd be great to come and talk to you about it. Updates to contracts and policies. It's literally everything we've talked about. You cannot get away from it. If you haven't updated your contract in the last 3 months, you need to do it. You need to do it now. Both Darren and I would be very happy to take a look at contract templates and give you a view as to whether it needs to be changed. But I can tell you, you're going to have to change. There's things here in terms of probation periods, in terms of training, in terms of flexible working, in terms of quality that all need to be reflected through your contracts now. We're very happy to take a look at those. No cost to us, just saying it needs to have this done to it. That's what we do all the time. And the same with policies. If you've not revisited your handbooks, you've not revisited your policy programs, do it now. How many of you have things such as AI policies? We've not even talked about AI, but AI is such a big topic now that we're writing AI policies for clients every single day, making sure that they've got a clear framework about what is or is not allowed in the workplaces. Those are things you should be thinking about, and you should be thinking about now. And if you've not thought about it, you've not done it, write it at the top of your list, particularly those contract things. Where are we going in the next 3 to 6 months? What are the things that you should be thinking about there? Reviewing of harassment policies and customer-facing policies and your commercial arrangements. Getting ready for that third-party harassment change, which Darren has referred to. That is coming. We can't avoid it. Our policies will be out of date. We will need to think about, again, how do we train our people? How do we get them ready for this? How do we make sure that they understand what is or is not acceptable? We need to think about how do we engage with our third-party providers. What are we saying to them in terms of our expectations? Have we educated them about the things that we expect? Have we done everything we possibly can do to protect our workplace? Now, what Darren's already referred to is the change in the Worker Protection Act from taking reasonable steps to taking all reasonable steps. That means everything, which means if you didn't do training last time, you're going to have to do training this time. If you didn't have a harassment policy last time, you're going to have a harassment policy this time, because you have to take all reasonable steps. And again, it's something which you need to think about and you need to talk to us about, please. Preparing for fire and rehire. I alluded to this previously when I was talking about fire and rehire. This is coming, but this is another really good reason to be making sure you look at your contracts now, because if you're hiring people now, you don't want to be in a situation in a few months' time where you're going, oh, crumbs, I need to change their terms, and discovering that you can't because you've got them in the wrong contractual terms. It ties in with my first recommendation also on the previous slide, because if you've got people on the wrong pay and conditions, you need to get those pay and conditions sorted out now, because you're not going to be able to later. Really, they're going to be stuck with them. So prepare for it, audit, look at it. How can we manage our people now? How can we get our contracts in place now? And lastly, looking further ahead as we go through 2026 into 2027, flexible working policies are going to need to be updated. Have you looked and audited your job roles? Do you know where flexible working is good? Do you need to make sure that you've got good information gathering so you'd be ready to push back on flexible working requests, or are you just going to accommodate and accept them? Trade union access, we spoke about that, getting ready in the context of how do you manage that and how do you deal with that? Have you got a framework in place in terms of what you're going to do when such things arrive? Have you thought about it? It's important to do so. And lastly, the equality and the many pools action plans, which are there. If you've got more than 250 employees, you have to do this. You're going to have to do it mandatorily by April 2027, and we'd encourage you to do it now. So how can we help? Herrington Carmichael, we do lots of stuff for you. As Darren and I both said, we'd love to get to know you better. We'd love to spend some time just meeting with you, chatting with you about what you do and how you do it. This is what we do. We give strategic advice. We do contract reviews. We do policy reviews. We do training. We do update processes. We do auditing. This is what we do. You might think we're sad, but we sit here and do this stuff all day, every day. And you know what? We actually really love it. It's part, and I hope some of our enthusiasm and our passion has come through. If you've got a camera phone, if you've got a phone now, I'm going to put a few QR codes on the screens over the next few slides that I talk about of things that you can sign up to. So the first one is our mailer. Now, our mailing list is fantastic. It goes out every week, gives you the latest thing in employment law, the most important stuff that you need to know, and it's there and it's available for you to access free of charge, no cost. So if you've got a camera phone there, point your camera phone at the QR code, it'll take you to a link and you can fill out and get signed up for our update. After this session, we will send around these slides and we'll put that into the details as well, so you can click on and you can effectively sign up for those. Through that mechanism, we're also going to be doing some fact sheets. We're going to be giving out some information in terms of the Employment Rights Act changes. We're going to be doing lots of different stuff. And it also means you can continue to get access to our updates. So every month we're doing updates. This was our April one. In May, we're looking at freedom of expression versus workplace rules around navigating belief. Such a difficult topic to manage, and so many different cases going through the courts and the tribunals currently about that balance between how do you encourage employees to have a freedom of expression while not compromising other employees' workplace beliefs, and such a battlefield for employees in terms of how do they maintain their employment. Again, scan to register. QR code is there. We'd love you to join us. Again, no cost associated with these things, just an opportunity for you to come, listen to what we're up to. And if this topic's not for you, scan on that mailer code before, which I put out on this previous slide, because we'll be disseminating them throughout the year. We do one every month. This might not be your topic, but there might be something coming up in the coming months, which is of real interest to you. And lastly, this has been Darren and me. We've had a fantastic time talking to you. And our favourite thing is when we get lots of LinkedIn requests after these. So the best way you can thank us is actually to be our friends on LinkedIn. So you've got our QR codes there. You can scan those now. You can join us on LinkedIn. And we use LinkedIn to disseminate information, to share it throughout. Gives you a chance to see some of our thought processes, some of our thinking, some of the stuff that we're up to. And we want to be your friend. It's as simple as that. So please do click on the link. Please do connect with us on LinkedIn. Come and find us. We're very happy to have a chat with you. And I think the last thing to say is how lovely it's been to see you all today. Thank you for taking the time to come and talk to us. I'm not sure we've got much time for questions. I don't think we've actually got many in there. No, we haven't, unfortunately, because I'm pretty much bang on time with the hour. We've done very well, surprisingly, for us, Darren. If anybody has got any questions, please do click those LinkedIn codes, stick us a message on LinkedIn, and we'll be delighted to effectively come back to you through LinkedIn, or drop us an email. Please do. And well, as we said, we'll be sharing those slides around, so you've got those afterwards, and you can come back to us on anything that's caused a problem. So I think the last thing to say is go and enjoy the sunshine. What a beautiful day it is outside. Thank you for all. I hope some of you have been sitting in the garden or sitting outside enjoying this session. It's been a pleasure talking to you. Thank you for coming to listen. And from Darren and I, unless you've got anything else you want to say, Darren, it's been a pleasure. Thank you for talking to us.